Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled Hong Kong Shipping Guide 2022. .6 Arresting bunkers and freight. The maritime landfall salvage attached not only to the ship but also to cargo, bunkers, freight, so that all the salvage property may be arrested. Bunkers and freight may not otherwise be arrested, although they may be frozen by way of Maleva injunction. 4.7 Sister ship arrest. Sister ship arrest is possible in Hong Kong but not associated ship arrest. So where the party liable in personam or the claim owes number of ships, the claimant can decide which one of those ships to arrest. It should be noted that whilst the claimant can name the entire fleet in its interim, it is only permitted to arrest of one of the vessel in respect of the claim. 4.8 Other ways of obtaining attachment orders. Security for a claim can also be obtained by way of the Maleva of freezing injunction, although this does not confer any priority over other creditors in respect of the asset. The main criteria to be satisfied by the plaintiff are: they have an arguable case, the court has jurisdictions in the matter, there is a risk that the defendant will remove or dissipate the assets. Another method of attaching the vessel is by way of a warrant of execution, which may be issued where there is a final judgment given by or an arbitration award of foreign judgment registered and the High Court. 4.9 Releasing an arrested vessel. Security for the release of an arrested vessel is usually given contractually by way of a protection and indemnity or P&I club letter of undertaking or a bank guarantee. The methods of security regulated by the rules of the High Court are the bail bond and also the payment into court of money, although they are encountered relatively rarely in practice. 4.10 Procedure for the judicial sale of the arrested ships. An application for the judicial sale of the vessel may be made on the basis that the vessel is a wasting asset because its value is being continually reduced by the costs and expenses of its arrest and maintenance, such that the judgment to be obtained may not be fully satisfied. In that regard, the plaintiff solicitors must at the time to arrest provide to the court an undertaking to pay the bailiff's costs of arrest and maintenance of the vessel. The court usual mode of sale in public invitation to tender, in other words, sealed bids. Whilst the order of priority of claims is within the discretions of the court, the usual ranking and distributions of the court sale proceed of the vessel is as follows. Bailiff's cost of arrest and maintenance including the bailiff's 1% commissions on the sale price, recoverable legal costs of the arresting party, maritime liens, mortgages, statutory liens, and non-maritime debts. 4.11 Insolvency laws applied by maritime courts. Hong Kong has no statutory equivalent of the United States. Chapter 11 of the UK's administration under process for the restructuring of companies. Foreign insolvency and restructuring proceedings do not, under Hong Kong law, result in an automatic stay of any Hong Kong actions against the company in question. As a result, warrant for arrest and judicial orders for the sale of vessels may be granted by the Hong Kong Admiralty Court in respect of vessel which are owed by companies subject to overseas insolvency proceedings. As regards Hong Kong insolvency law, the courts have jurisdiction to wind up not only companies which are registered in Hong Kong but also overseas registered companies where there is, amongst other criteria, a sufficient connection to Hong Kong, the presence of the overseas registered ship-owning company's vessel within Hong Kong waters would provide the basis for such jurisdiction. When a winding up order has been made or a provisional liquidator appointed, no action shall be proceeded with against the company except with leave of the court. The court will, however, grant leave to continue the proceedings to secure creditors, for example mortgage, maritime lieners, and statutory lieners whose interim writ was issued prior to the date of the winding up order. 4.11 Damages in the event of wrongful arrest of a vessel. The ship owner will only be able to recover its losses due to a wrongful arrest where it can prove that the arresting party or its solicitor acted in bad faith or was grossly negligent. This is a high threshold to cross. 5. Passenger claim. 5.1 Laws on conventions applicable to the resolution of passenger claim. The 1974 Athens Conventions concerning the carriage of passengers and their luggage by sea is given effect in Hong Kong by the Merchant Shipping Ordinance Cap. 434 Any actions for damages arising out of the death of the personal injury to a passenger or for the loss of or damage to luggage is time-barred after a period of 2 years. The convention applies to international, not domestic Hong Kong carriage. The London Conventions, in example the 1976 Conventions on Limitations of Liability for Maritime Claims, together with the 1996 Protocol or LLMC, is applied in Hong Kong by the Merchant Shipping. The LLMC provides for limitations by reference to the vessel's tonnage, which may be relevant in the event of serious casualty. It should also be noted that the Control of Exemptions Clauses Ordinance prohibits the carrier for excluding or restricting its liability for death or personal injury resulting from its negligence. 6. Enforcement of law and jurisdiction and arbitration clauses. 6.1 Enforcement of law and jurisdiction clauses state in Bill of Lading. For a Bill of Lading, as for any maritime commercial contract, the Hong Kong courts will uphold a choice of law clause. Exclusive jurisdiction clauses will similarly be given effect unless there are strong reasons of exceptional circumstances for departing from them. A party who contests the appropriateness of the named forum has a heavy burden to prove that the interests of justice are such that the contractually agreed choice of jurisdiction should be overridden. 6.2 Enforcement of law and arbitration clauses incorporate into a Bill of Lading. For a shadow party arbitration clause to be incorporated into the relevant Bill of Lading, Hong Kong law requires that the Bill of Lading make specific reference to the arbitration clause to be incorporated. This requirement under the Hong Kong law for specific word incorporation also applies in the case of jurisdiction clauses. 6.3 New York Conventions on the Recognition and Enforcement of Foreign Arbitral Awards. Hong Kong is a party to 1953-58 New York Conventions on the Recognition and Enforcement of Foreign Arbitral Awards. Sections 87 of the Arbitrations Ordinance provides for the enforcement within Hong Kong of conventions arbitral awards. So that's all the article. Don't forget to watch the previous video, and also don't forget to like, comment, and subscribe. And bye bye.